Hello, and welcome to Crime in Court. My name is Heather, and this is, as it shows here, this is episode 6 of the Mistrial. You can see Judge Schroeder in he's the largest one there. Behind him is Prosecutor Michael Gravely, who we will hear from throughout this episode. And then obviously we have Zachariah in the blue suit. He is who this series is about, Wisconsin versus Zachariah Anderson. And then the woman who is smaller on the page, she is Sadie Beecham. This is the woman who the ex partner of Zach's, and she started dating someone new, and someone disappeared, and now Zach at this point in time, Zach has been arrested. Trial has concluded, and he's been sentenced, and shown or convicted as a guilty man for the disappearance of someone. Well, basically, we don't have confirmation because we've never found a body. And also the fact that he was stalking Rosalio, that has never been proven either, in my opinion. But those were the charges, plus stalking against Sadie. So he was found guilty on all 3 charges. Rosalio's unaliving, and then the 2 stalking charges. So in this episode, we're going to cover the mistrial. They had a trial back in, as you can see, it was March 15th, 2022. So that is already 2 years now that Zachariah has waited to get to trial. At this point, it's been 2 years for whatever the issues are. I mean, it takes a while to prepare for a trial. And I don't know why it took 2 years. I'm sure there might have been some issues with discovery delays and things like that, because that always slows up the process. But I don't know all the details on that. I will tell you that this document that's in front of you right now is it's the very first day's transcript of their mistrial. So it went 2 days, and there was a mistrial on the second day. So we're going to read through the mistrial transcript just to kind of see what happened. But I do want to go through the transcript from day 1, just a short portion of it, because basically the only thing that happened on day 1, besides maybe possibly jury voir dire, was opening statements. So Mr. Gravely, Prosecutor Gravely, made his opening statements, and following that, Nicole Muller, for the defendant, made opening statements. But what we're going to talk about is this portion of Gravely's statement, or opening statement, because there's some issues with it, and this is what causes the mistrial. So he says, he's talking about, this is all the stuff that you're going to find that you'll hear throughout this trial. He says, you'll hear that a woman named Nerita Macias had met Rosalio on a dating site, and that on the 17th, in the evening hours, she was going to meet him for the first time at his house, and so they were texting back and forth. She was driving from out of town. It was going to be about an hour drive. They are in contact where Rosalio was clearly indicating to her, I'm expecting you, here's what I have to drink, here's at the house, all that sort of basic details of her coming to see him at around 9:30, the night of May 17th. which is the night in question that they're saying is the night that Rosalio disappeared, and claiming that that's when Zach did something to him. So you'll hear that the last time she had a text from him was at 9:30 on the 17th, and then she gets there at 9:37 p.m. and she begins to text him, "Hey, I'm here," or "I'm 5 minutes away, then I'm here," and there is no response. I mean, this is a guy who has been texting her saying, "Come over, here's what I have got to drink," and there is no response. And she continues to text and to try to reach him, and she says, "I stayed there until around 10:19, so give or take half an hour, a little less," and then she says, "I drive away." It turns out that she is in front of the wrong building at Wood Creek. This is according to Prosecutor Gravely. You'll hear that there's text messages from the very first time that Sadie Beecham went there, that she was being warned by the defendant, or in some way there was a communication between them that, hey, GPS is going to take you to the wrong building. And you'll hear testimony that, in fact, for whatever reason, the wrong building is where Nerita Macias is. So she is waiting outside the wrong building. She is, of course, keeping an eye, but never sees anything or anyone because she is in the wrong spot. Not in a location where this patio door of Rosalio's is visible in any way, and then she leaves when he doesn't get back to her. So she gets in touch with law enforcement later saying, "Hey, I just need you to know I was there and he never came out and never contacted me and never has contacted me since." So again, showing that this is not an individual who is missing in some accidental circumstance other than the deliberate causing of his unaliving. And that's all I'm going to read from this day's transcript. So as you can see, the state's theory going into this trial is that Nerita Macias, one of the key witnesses for both sides, is sitting outside the wrong building. And this, however, is news to the defense, because the next morning they start off the day outside of the presence of the jury. Ms. Mueller says, "Judge, this is a matter to handle outside the presence of the jury." The court, or Schroeder, says, "What's up?" She continues, "Yesterday during opening statements was the first time that the defense heard that Ms. Macias was in front of a different building other than 3709 15th Street, which was the apartment building for Mr. Gutierrez. This morning, it was confirmed that months ago, the state took Ms. Macias to the location and basically asked her where she was. This new statement about where she is, or where she was, it's a completely different place and is extremely inconsistent with the state's statements that were provided to the defense, which was that she was at Mr. Gutierrez's apartment, and this isn't something that the state has known just for a brief while. According to the state, this was done months ago, and so we have a drastic change in a witness's statement. And really, under Brady, the defense would have been entitled to that before this trial started, and so I don't know what happened. I don't know why the defense wasn't notified of this drastic change in a witness's statement prior. We weren't informed of it at all, actually. We had to learn about it through an opening statement, so we would be asking that evidence not come in." The court says, "Mr. Gravely?" Mr. Gravely has a chance to respond. He says, "Yeah, Judge, when last we were prepared for trial in this case, we had Ms. Macias come to the DA's office. A member of the DA's took Ms. Macias to the scene." Remember, notice he says a member of the DA's. A member, one. A member of the DA's took Ms. Macias to the scene, which is not an uncommon occurrence on a homicide case. And when we got to the scene, so kind of putting himself there, but when we got to the scene that we knew because I had been at the scene of the actual homicide, Ms. Macias was not there, and we asked. So now he's talking we. We asked, "Where are you?" And she said, "I'm here." And we said, "We are here, and so where are you?" And she described where she was, and we drove around and found that she had been at a mistaken location, believing that she was outside of Rosalio's building, but not outside of it. She actually was not outside of Rosalio's building, according to Gravely. So this was members of the district attorney's office who were present. Law enforcement was not present. This is not a statement that was taken, and it's not exculpatory, so there is no Brady obligation. And we talked about yesterday in some depth when the state is prepping and talking to witnesses, new developments occur, and that's what occurred in this case, and it's not something I will surprise them with. I told them about it in the opening. It was prominent in my opening, and from the state's perspective, there is no obligation to describe an interview we had with this witness, which is not a recorded statement. The court asks Ms. Muller, "Do you wish to respond?" And she says, "Attorney Birdsall will be responding for the defense." And he says, "It's not a statement. It's obviously a statement. It's a statement of a witness that he had an absolute obligation to disclose, and it's not just any statement, it's a critical statement, and I don't know what's going on or if this was some purposeful, sleight of hand on his part, but to say, well, we disclosed it during our opening statement is ridiculous, and this court knows that, and it's ridiculous to call this not a statement because what it does, it changes the timeline about when things could have happened because she was very clear in her original statement given years ago. Now, she was very clear about where she was and what she observed. And so, frankly, I don't want to throw around the word misconduct, but that's what it kind of looks like. Number one, and number two, this should be a mistrial if it's not going to be. If you are going to allow, in other words, either don't allow them to present this evidence or declare a mistrial. Mr. Gravely says, "Can I speak, counsel?" In my response, how many times they have spoken to Ms. Macias, who they believe to be a witness. Her statement has always been, "I have never been to this individual's home before. I arrived at a place I believed to be his home and waited outside and never got a response. He never came out." So this is not a person who has visited his home before. They have indicated to the court that this is key to a timeline that they have. My inquiry is whether they spoke to her at any point. Again, this is not exculpatory evidence, and it is not a statement. And there are an infinite number of times when the state preps people that they make adjustments in what they say. Ms. Muller says, "Judge, can I answer that? Naturally, our investigator reached out to Ms. Macias multiple times in an attempt to speak with her about her statements. It was never responded, and if we need to get an affidavit from our investigator and proof of how many times she did that, she sent multiple letters, went to her residence, it was never responded to. Part of the difficulty about being defense counsel is that sometimes those are speed bumps that we get to, obstacles that we can't overcome. This is drastic in the sense of I gave an opening statement where I provided a very detailed timeline and told the jury what that timeline would say and what was based on the information in the discovery that we had. The state, if they knew they had something to completely obstruct and disarray that timeline and not provide it to the defense prior to trial commencing, that's an extreme injustice to the defense." She is so well spoken. I really like this, Nicole Muller, Ms. Muller. All right, so the court responds, "Why don't you cite the authority for me that required the disclosure of this information?" Mr. Gravely says, "And I did cite this in my opening. I apologize, Judge, but I talked about this in my opening. So for counsel to say I opened without this information is false." And the court responds, "Well, yeah, I don't like to use the word false because false has an ingredient which suggests that it's willful, but I understand the point you are making, which is that she had already heard your opening when she made hers, but I was a little bit taken aback when you referred to providing information to the defense for the first time during opening statement. It is kind of late if it's required, which is why I have now requested the defense to cite the authority for the obligation of the district attorney to have disclosed this information." Mr. Gravely responds, and I would like to add one more thing to the record. We are prepared to Google map the address of Rosalio Gutierrez. In other words, this numeric address right now, and show the court that Google map takes you to the wrong building because that is what occurs. So we don't want to put Ms. Krajcerik's phone into evidence. Krajcerik's, I think. I think the J is silent. Anyways, but if we Google map using a phone app, the court responds, we might be here for weeks. Mr. Gravely, it will show that it is the wrong building. So using a very common app, we did it just now this morning. I'm happy to demonstrate that to this court again, that it takes you to the same building Nerita Macias tells us that she went to. Ms. Mueller says, Judge, before, and Mr. Gravely interjects, I apologize, and I know I stopped, so I'm not perceiving an interruption, but I had one more point, and I took a breath. And this is that I don't know if counsel has gone to the scene and whether they used a Google map, but again, if they have actually gone to the scene, I would anticipate they would have the same issue. Ms. Mueller says, thank you, and I am going to answer to that, and then Attorney Aubert is going to answer your question about the legal authority, Your Honor. First, I have gone to 3709 15th Street, and I put it in my maps, and it took me right to the building. Also, if they are saying we are going to introduce this map, well, how do you know that that is what Ms. Macias used on the day that she went there? We can't just, there are so many different, there are ways, Google Maps, there is a bunch of different ones you could do. Maybe she sends you someplace, but without knowing which one she used, I don't know how offering up any sort of direction would be relevant. So that's to that point. And then Mr. Aubert says, Your Honor, Attorney Mueller and Attorney Birdsall, that's the whole defense team, the three of them, have already stated the significance and importance of this particular piece of the information in that both sides in a case like this, the court is well aware this is all circumstantial evidence, so both sides are trying to piece together a theory as to whether what happened and the timing, as to what had happened and to the timing of events. So remember, this is a no body case. Rosalio's body has never been found. So everything in this case is circumstantial against Zach. So, I mean, yeah, you can grab a bunch of little things that make him look bad, and then, it just makes him look bad. It makes him look guilty. So it's easy to spin a tale, but anyways. All right, I'll continue on. We have been in possession of the discovery. This is Gravely still speaking, of the discovery in this case that relates to this particular statement for many, many months. And obviously, this is Aubert speaking. They have been in discovery of this statement, the original statement, for many, many months, and obviously a case of this complex nature we have been preparing diligently for many, many months. Anytime there is a statement of a critical witness which both sides are relying upon being able to anticipate what that testimony shall be, that is the reason why the prosecution, or for that matter, the defense, must provide, statements of what the person should be. So the issue seems to be, does the DA's office have an obligation under these circumstances to memorialize it? But the court says, I asked for the authority and you are telling me it seems to you, and Mr. Aubert says, and so the court says, I have the utmost respect for your knowledge and ability, but if I cited that as an authority, the Court of Appeals might give me a spanking, he says. Mr. Aubert says, right, they wouldn't like that. I agree. Brady versus Maryland and Kiles versus Whitley, and of course, those are Supreme Court decisions that deal with whether something is not only exculpatory, but could lead to potentially exculpatory information. When we have a statement that has been provided by the prosecution upon which both sides are supposed to prepare, and then the prosecution knows full well that there is going to be a dramatic change in any witness's testimony, an inconsistent statement, the coming of light that now the statement which we have in our possession, which we are using to prepare for trial, now is very different. That is not only potentially exculpatory, but for any reason that changes this testimony is subject to cross-examination and should not be revealed during the opening statement by the prosecution. They have known for months that there is going to be this 180 turn on this issue and didn't let us know, and that would be critical. And by the way, the inconsistency on something that is like the heart of this case, they should have known full well that that would have an impact, not only in our preparation, but would have been extremely useful in cross-examining this witness and would have required further investigation. Kyles and Whitley, in particular, talks about information that could be useful for the defense in furthering their defense investigation into what happens to develop further factual information. So it's not, I know what Mr. Gravely is saying. He is saying she didn't change her statement to make it better for the defense. She changed her statement to make it worse for the defense, is what he's saying. It's like an inculpatory. It's worse, so we don't need to tell you. Okay, it doesn't work that way. You have a witness who makes a statement to law enforcement and then accompanies the district attorney and whomever else is there and says, "Oh yeah, you were right. I got this all wrong." And they don't tell us, and they don't tell us in some way. I cannot imagine that Mr. Gravely, I'm sorry, I was looking at something else when he was talking about exactly what happened, so I didn't hear the full thing, but I doubt seriously that he went by himself with this witness. I'm sure that somebody else was there, and the reason that you take somebody else there, I'm assuming somebody else who is not a lawyer in this case was there, that is trial prep 101. You don't take yourself you don't make yourself a witness. Okay, you bring somebody with you from victim witness or a police officer when you are spending time alone with the prosecution witness, and then yes, you are right. You do run the risk of that person saying something to one of the attorneys if you don't have anything else there that you can call as a witness. Anybody else there that you can call as a witness, or to write a report, or to call in rebuttal. I'm going to take a sip of water here. So as you can see, he's making the argument that if you are to take a witness, someone who is not necessarily a part of the investigation, so maybe a property manager, or have a third neutral party present, you don't want the prosecutor there telling the witness or implying certain things to the witness. And without anybody else there, then that prosecutor then would become a witness because there's no one else around. That's basically what they're saying here. So it's trial prep 101 that if you do take a witness somewhere, you the lawyer, bring someone who is a non-lawyer, maybe law enforcement, somebody neutral, that you can depend on their credibility for statement, if they have to provide a statement or testify on the stand about what took place there. So you do not run the risk of that person saying something to one of the attorneys if you don't have anybody else there that you can call as a witness, or to write a report, or to call in a rebuttal. So why would somebody do that? Why wouldn't you do that? We wouldn't take a witness that we anticipate is going to testify and be alone with that person and hear what they have to say without any, first of all, proof of what the person said, or the ability to call a witness that would demonstrate what the content of that was. So was this a deliberate effort so they wouldn't have to produce a report because it is only lawyers prosecuting this case that hears this? That's wrong, and that is just plain wrong. So is that them doing it deliberately so that they don't have to write some kind of written or make some kind of documented report that they went there with her? And then Mr. Gravely says, well, Mr. Aubert says, let me finish, please. I think the court can see that this was obviously a huge revelation, and Mr. Gravely even relied on this fact in how important it was. We, as the court, can tell, and as Attorney Mueller said, we tried repeatedly. We did our due diligence. We tried to talk to this witness. She dodged us, evaded us, didn't want to talk to us. Not that there is anything wrong with that, but she has allied with the prosecution. So that is important to know. Narita has allied with the prosecution, apparently, and she does not want to talk to the defense. I don't understand why people hate defense attorneys so much. I mean, defense attorneys are the only people that protect our constitutional rights. Prosecutors don't do that. They stomp all over our rights. And law enforcement doesn't do that. They stomp all over your rights trying to get a charge to stick. That's their sole purpose. So, yeah. Anyways. All right, so she dodged us. I know that happens. All right. So the issue is that we spent, how long has it been now? A year and many months preparing for this case. 2 years. Well, he didn't get arrested. He was arrested right away for the stalking, but I don't think he got charged right away for Rosalio's disappearance until a little while later, that they could prove that he was really gone or something. I don't know. Or not, I don't know how they proved it, but provide more evidence, collect more evidence to show that he was not going to be returning. Anyways, so a year and many months preparing for this case, every minute detail of this, working things out, hiring experts, doing everything that we possibly can to be ready for this trial, and we come in and have everything lined up with the complexity of the facts that we intend to present to vigorously defend this man. And for the first time ever, we hear a completely new story about the events that we have been relying upon. So at a minimum, an inconsistent statement where a critical witness is going to change what they observed and where they were, which obviously the prosecution was very happy and excited about that when it happened. I can't imagine that they wouldn't have thought this is beautiful. That's our linchpin to the case. Of course they thought that. And we don't get to hear about it until after the jury is sworn. I mean, not only should this be a mistrial, it should be a mistrial with prejudice. And again, don't cite me, the Court of Appeals won't like that. Meaning, with prejudice, I believe, is that they cannot come back at you with the charges, and then without prejudice means that they could charge you again with the same exact thing. So, and again, don't cite me. The Court of Appeals won't like that, but this is, I hope the court can see here. We have already relied upon, and the court expects us to, and we have put in hundreds upon hundreds of hours preparing for this case, as you want us to, and as we have done. And this is not the kind of case where we show up and let's see what happens. We have 60 binders full of material that we have brought with us. We have met every weekend for months and months and months on this thing. We have explored every possible angle on this to prepare for a case, not knowing that there is a critical issue out there that they hit us with months later as a surprise attack is what is going on here. And that's not fair, and that's not due process. And I do think this is unconscionable that we are put in this position. It appears to be deliberate. It appears to be 100% deliberate. Now, I would have great difficulty believing that upon this revelation that, that throws off everything else that is already in the discovery, because the discovery we have places her there. It's critical to our timeline. It's critical to our theory. It was critical to their theory until there is this sea change in the events that led up to the time period. And by the way, Judge, I hope you can see what this does. We all listened closely to Mr. Gravely's statement. This changes everything in terms of the time frame that Mr. Anderson theoretically would have had the opportunity to do this, and we have been relying upon the fact that this witness, based on what we have, would have placed her there, because that's what she originally said, and she said she was watching this place for between 30 and 40 minutes, and the theory that we heard it in the opening statement is that during that time we heard about plastic sheets, wrapping things up in carpets and blankets and sneaking it out through the patio door where it would have been just feet away. So part of his opening statement was that Zach was wrapping Rosalio's body up in the carpet and carrying him out to his truck while at the very exact same time that Narita would be sitting there. So obviously, if this witness was there, as she told the police originally, she would have seen what was going on. She would have seen Zach, if that was happening, she would have seen that. So that throws the timing off. So now all of a sudden, to account for that potentially problematic fact in the state's case, she is in a different location. She is in a completely different location. That solves their little problem with the case, and I can tell you that that is fundamental to our defense in that very fact. So first of all, the authority that I have cited is clear. It goes beyond just providing clearly exculpatory evidence. Obviously, if somebody says, they have evidence that completely disintegrates the possibility that somebody is the true perpetrator, yes, of course, they have to disclose that and find a way to disclose that, which is, again, why they should have had somebody present. But it goes beyond that. It goes to, and I'm sure the court has seen this many, many times, when there is the existence of an inconsistent statement that they have in their possession. They know that a witness that they are going to call is going to change her testimony from what she had previously told the police. They have known that for months. They have known that this is going to be a shocking zinger of a moment in the trial, and they kept it up their sleeve. They hid that from us, and they sprung it on us during opening statement. I'm sorry if I sound upset here, but we have put our heart and soul into preparing for this case, and now all of a sudden we are caught scrambling. Mr. Birdsall says just a couple things. Mr. Gravely says no. The court says, yeah, I think I'm going to limit it to, usually they try to limit it to one attorney doing the arguments, and Mr. Gravely says 3 arguments. The court says, what did you have to say? Mr. Gravely says, well, I just want to say it's the most passionate and longest argument I have ever heard to indicate I have no additional authority, which is what you were told. And the court says, well, I'm not on that boat yet. And Gravely says, okay, well, I want to show you that the statement from Ms. Macias, you have heard a couple of charges that, I apologize, Judge, but I believe are outrageous charges, and one of them is that this is a clearly inconsistent statement, so I'm going to show this to the court. I'm going to ask the court if this is simply a person trying to explain why she might say what she says, or whether there is something in here that says it's inconsistent. I'm going to tell the court I read this statement to say, Rosalio gave me his address. I went outside the building, his building. I never confirmed the address. I didn't go in. I have no independent knowledge. I have never been there before. She doesn't indicate in any way that she recorded it. She simply went to that address. I can tell that the court when we Google map it, we go to the same place that she went using Google Maps, a common app. We get the same apartment that she went to, so counsel may have a different mapping pursuit, but this, from the state's perspective, is not something that is wholly inconsistent. The court says, I know that, but why would you assume that they would automatically use Google Maps? That is kind of what you are assuming. He says, yeah. The court reads a document. Then Ms. Mueller steps in and says, Judge, it is Kyles versus Whitley and then Strickler versus Green. Mr. Gravely says, pointing to a particular spot or not. So they printed up some case law from these things, and they're pointing to the specific lines in it and pages. Okay, Mr. Gravely says, okay, thank you. The court says there is no recording of, was Ms. Koceric alone with her, or was there someone else? Mr. Gravely said multiple people were there. The court asks, did anyone prepare a report in writing? Gravely says no, and the district attorney's office would never do that. The court says, well, my initial reaction is, I think this should have been disclosed at an earlier point. Now, should is, I'm using that in a sense different from required. I don't know the answer to that, but it's not clear to me at this point. I think I'm understanding what you are saying when you invested heavily on the assumption of the accuracy of the original information. But when you are talking about the kinds of remedies that you have, I'd have to have a much clearer picture of the situation than exists right now. I am not in a position to say at this point that it is required to have been disclosed. I may come to that conclusion, I don't know. I would certainly not conclude at this point that it's exculpatory or tends to lead to discovery of exculpatory information. Ms. Mueller says, Judge, if I may, the court says, well, go ahead. She says, thank you, and I'm sorry, I didn't mean to interrupt, but co-counsel here was referring to this as potentially exculpatory information, but under an analysis of Kyles versus Whitley and Strickler versus Green and Brady, if the state's looking at this evidence as evidence of guilt, right, this is evidence that increases the time frame from their theory that Mr. Anderson would have had to have committed the crimes as charged, that would be inculpatory information, which the state under 971.23 absolutely has an obligation to disclose. Further, the court says, wait a minute, what does it say? What is the exact wording of that? An unrecorded statement. Mr. Gravely says, what was the statute cited? She repeats it, the general discovery statute. Okay. So when we look under the discovery statute, it talks about any relevant and or recorded statements of a witness named. The court asks, written or recorded? And Ms. Mueller continues, just under subsection 1E and just the nature of that, although it doesn't say you have to prepare a report, but it is relevant. It is a relevant witness, a relevant statement of a witness. And when we look at the second clause of that particular provision, it talks about if an expert doesn't prepare a report or anything, you have to give a written summary of what their testimony is going to be, right? And the reason that the legislature puts that in there is so that the court says you are jumping to another statute or another subsection. She says, no, this is still under section E. Mr. Grayley says she's saying the second half of the clause is regarding experts and she is paralleling. The court says, that is what I mean. You're jumping to another concept. Ms. Mueller says, I was just trying to make an inference. He says, Judge Schroeder says, I understand. Gravely says, can I? The court says, well, here, no, we are going to shorten it if you hear what I'm thinking. Mr. Gravely, okay, I apologize. The court continues, somebody commented during a recent trial that Schroeder thinks out loud. Well, I do it deliberately so that people can say, oh, you are all wet. And so I'm thinking the statute's strictly construed says written or recorded. Then it's not, and there is also no obligation that they make a record like that. Maybe it would be a prudent practice, but it's not required, and so that it becomes a question of whether or not they were slyly concealing it or withholding that information. And as Mr. Aubert has aptly pointed out, there are many things that are so explosive that the district attorney would have a clear obligation to understand the significance and to convey it to the defense. I'm not in the position to say that at this moment in time, but I'm not going to exclude that possibility either. It depends as we progress with the trial. Mr. Gravely relied, this is an impactful statement when he was making his opening statement, that this was of significant importance in the case. But as we progress with the case, I don't know how important it actually will be, nor will I have a really good sense of what would have happened had he disclosed it. Such a long, I love these long run-on sentences. They're hard to read, so let me back up a little bit. I don't know how important it actually will be, nor will I have a really good sense of what would have happened had he disclosed it. What is likely to have happened if he had disclosed it, and whether that I referred to before actually become a requirement. And so I can't tell you at this point. This judge is so wishy-washy and it annoys me. I hate wishy-washy judges. I might also add that there is a section in the statutes regarding failure to make discovery that one of the remedies that is prescribed by law is that the court will give an instruction to the jury about what the district attorney's obligation was, and that the jury can consider the failure to, if they find that the district attorney failed in his duty to comply, with the requirements of the law, then that is something that the jury can lawfully consider. So I don't know if that might be a remedy, proper remedy, if I find that there was a violation. So I'm way away from that point where I would need to be in order to make a determination. That's too bad, because I would hate to put 2 weeks into this trial or a week and a half into this trial and then decide, well, I do have a bigger problem then. Mr. Gravely says, I want to put the court, if I can. He says, yeah. I just want to put my head into the court. Have the court hear my thinking out loud as well, just in case it assists the court, so that the court does not have 2 weeks before it can make the substantive decision. From my perspective, the statement of Nerita Macias is a statement which the state will have to think about to decide whether it is going to be a problem. It is similar to if I have a person who is in custody and I'm charging them, and let's say a person was to give a completely different description of the person they saw at a scene or something like that, right? So to me, it is analogous to that, and to the state, of course, would attempt to investigate that and attempt to see if they would explain why that happened, okay? Why is this documented issue not a thing that the state will have to worry about, or the state will be a concern? And we do that all the time. What is he talking about? I interview a witness and I say, well, you say in here that the person was wearing a black jacket. Can you tell me why you think it was a black jacket? And he might say it was very dark out, so consequently, it looked to me like it was black. And so then I would have the additional information to explain it. This is what happened here. She gives a statement. She doesn't say definitively, I was at that address, and I'm sure I was at that address. There is no reason to believe I know she had not been there before, and so the description with her was, can you indicate to me where you were, and she can indicate where she was, and that explains that piece of information, just as a difference in identification would be explained. Again, I don't buy that argument either, but again, I don't perceive that, and I don't think I ever have perceived that as something that, if it is not a written statement, would then have to be disclosed. It explains a statement that is in existence. I'm aware that the defense is doing the same, and it's possible they will get people explain why certain things have been said as they are. That isn't a surprise. That's not a change in the litigation. Both sides, of course, are doing that. Thank you. Mr. Aubert says, Judge, I do have some additional authority I'd like to put on the record, if I may, just for the court's consideration, and the fact that if we can, and I know the court is concerned about the Wisconsin discovery statute that talks about written and recorded statements, and I understand all that, but what we are really talking about here, and I think the court mentioned this, is that we are not looking just about what the legislature puts the state on notice of in terms of what they must provide in a statutory sense, but we are in the realm here, and I'll be very specific, Kiles versus Wheatley, Strickler versus Green, in the sense that includes very specifically impeachment evidence, as I've said before, and those cases stand for the principle, and there's no causes that talk about the timing of the disclosure as a due process issue, and we have trial by ambush, which is what Kiles is supposed to prevent, or Brady for that matter. The timing is also important. And there are a couple of cases on that point as well. I'll cite Weatherford versus Bursey, and then the Supreme Court case United States versus Farley, which is the Sixth Circuit case from 1993. The court says, I'm sorry to interrupt, but I'm not struggling so much. I'm not struggling at all, really. I don't have any problem with the general statement of the law that you are giving me, that there is a point at which the district attorney is required to disclose certain things. And I have already said that I think this should not in the mandatory sense, but should in the sense that I think it should have been disclosed because it was a significant departure from an earlier statement. But I really can't identify the extent of the problem as the evidence develops. We'll get a better sense of how expansive our problem this is. So he wants the trial to just keep going, and then he can see how big the problem is versus, correcting it now or doing something about it now. And I certainly am not going to embrace the suggestion that the district attorney is guilty of some sort of misconduct at any level. But on the other hand, I'm certainly not going to conclude that he's not. We have to look at all the evidence, and then we'll get a better idea, and not only what the evidence is, but also its effect upon the case. And I think you both pretty clearly made clear your respective positions and your positions that you really, really depended a lot on the accuracy of what you assumed to be the correct information in the preparation of your case. So I'm aware of that, but I don't think it's something that I could make a decision on right now. Mr. Gravely says, okay, how would this be impeachment evidence? How would you impeach Ms. Macias saying, I have never been here before? I thought I was at the right address. And the court says, I wouldn't call it classic impeachment. Mr. Gravely says, that is what the site is. The site is impeachment evidence. The court says, the current status of her statement is at variance with which she perceived to be her original statement. So, and we can tell, she's obviously saying two different things here. Mr. Gravely says, sure. Court continues, as perceived for good reason. So I don't want to get into that. No, we'll leave it at that. I'm not prepared to rule on this at the moment. I'm aware that there is an issue and will proceed. Mr. Gravely says, can I have the statement back or do you need that? The court says, okay, give me a copy later. Ms. Mueller says, I'm taking back the mic. The court's concern about not being quite sure about how this is going to impact everything, that change, that is also a concern that is shared with the defense, right? I don't know. We still don't know exactly what Ms. Macias said. All we have is a representation made by Mr. Gravely about what she may say. There might even be more, and I, too, don't know about how they are going to, throughout their entire case, how they are going to talk with different witnesses, how this is going to be used without knowing really what evidence is. And it's extremely unfair to the defense to say that we have this outstanding issue. The court responds, I'm not going to buy that because this is, and I think Mr. Aubert made some reference to this earlier, this is a chronic issue for the defense. You don't know what the witnesses are going to say. It is not unusual for witnesses to be non-cooperative with the defense, and when somebody gets up there, you really do not, even the prosecutor doesn't either. I saw that very recently illustrated in a big way. A witness can blow up, or witnesses can blow up right in front of the DA, but the defense is at even higher issue. So the fact that you are in a state of uncertainty as to what may develop, that's nothing unique to this issue. Ms. Mueller says, I understand that. I understand that, Your Honor. However, Ms. Macias isn't going to be the first witness that the state calls. So what she has provided previously and that timeline that we have, that impacts how we question other witnesses in this case. And so if we go and we are questioning, and if she is going to say something completely different, and I still don't know exactly what she was going to say, that has not been provided. It could be that we get to Ms. Macias, and now we just spent 3-4 days questioning and getting evidence that is now completely the defense prepared it in a way that went nowhere. And so then what are we going to have to do? Recall all those witnesses. And the court says, is there some reason to believe that she is going to have some other departure other than the location, which isn't actually a departure? Ms. Mueller says, at this point, I don't know what other departure she is going to have. The court says, I don't know. Is there reason to think there will be? Ms. Mueller says, perhaps there will be. I don't want to deal with perhaps. This is all speculation. I'm ready for the jury. Judge, just one other thing, Ms. Kazarick says. This is convictions for potential civilian witnesses, just to run through them real quick. So we only have to do this once. He says, yeah. Ms. Kazarick continues. Celia Patterson, there was one conviction from 1983. I don't believe that counts, but I know the court makes its own findings. The court, did we comment on that? No. We would have no objection in the court. If it was for perjury, it might come in. What was it for? She says it was not for perjury. What's it for? Looks like issuance of worthless checks. The court says, well, that is a crime of dishonesty, but that is very old. That is a very long time ago. That is the year I came in here, so that is 39 years ago, so we won't bring that in. Ms. Kazarick continues, Christy Raditz Ortiz does not have any criminal convictions, but does have pending charges. So that is, all right, subject to cross-examination. Ms. Kazarick continues, subject to cross-examination. And then Christine Remsburg has 5 convictions from 2015 to 2014. Criminal trespass to dwelling, possession of an illegally obtained prescription, possession of hazardous substances with intent to abuse, substance paraphernalia, and possession of MET capital H. I don't know. All right, so those, I just don't want the YouTube algorithm to pick up bad words. So those are within the 10-year rule, a total of 5. The court says, did you want to comment on those? Mr. Bursall says, no, we don't have any comments on any of those, but I quickly want to revisit. The court says, you know what? I have to say that I was taught, and I believe it to be true, although I have such a magnificent reporter here, and I was bragging about yesterday, and she can do things that others can't, but the rule I was brought up with from law school on is that only one lawyer to a party with rare exceptions. So I'm going to hear you out now, Mr. Birdsall, but as a general statement, Ms. Mueller is speaking for the defense. Mr. Birdsall says, we have been trying to do that, and I appreciate that, Judge. He says, try harder, but what did you want to say? Mr. Birdsall says, I will try harder. I wanted to clarify for the record exactly who, that cracks me up. It's like, okay, but you're asking for case law, and you're having an argument. You need somebody to be paying attention to the argument, and you need somebody to be pulling up the case law and looking at it. You can't be both of those people. So I don't know what the judge is being all annoying about with one person only talking, but whatever. Hold on, time for some more hydration. All right. So Ms. Birdsall says, I will try harder. I wanted to clarify for the record exactly who was at this interview that took place with Mr. Gravely, and apparently this district attorney, or assistant district attorney, and who else was there, and if there was a non-lawyer there, because if there wasn't a non-lawyer there, then I guess they are witnesses. The court says, it was not my impression that Mr. Gravely was physically present. Mr. Gravely says, I was there. He says, I was there. Remember, he was saying, we were contacting Ms. Macias. We were asking her, are you at the right building? Where are you? So him and Jessica Kazarick, the assistant DA, were in attendance that day. So the court says, oh, you were. Okay, who else was there? Ms. Kazarick was there. And who else? No one else. So they are witnesses, Judge. Well, at least one of them. Well, they are both witnesses. Mr. Birdsall says they are both witnesses. The court continues, well, we don't know if they are going to be witnesses. Mr. Birdsall says, well, guaranteed we are going to call them because there's a change in circumstances. There's a change in statement. Mr. Gravely says, there is no change in statement and there is no statement taken. So the court says, but each of you is a witness to a statement of another witness. And are you telling me that the defense can't call you in good faith to examine you about what was said by Ms. Macias? Mr. Birdsall says, therefore, they can't be the lawyer, so they are going to have to get a special prosecutor. The court says, well, let's take a step at a time. Mr. Gravely says, I don't perceive it as a statement that was made. I never did. We showed up and she said, the court said, yeah, it's a statement. If you asked me, what year I graduated from high school and I tell you, it's a statement. Mr. Gravely says, well, we did not anticipate this occurring when we went over there. Yeah, you didn't anticipate getting yourself into this mess. All right, so we went over assuming that she would show us a location, and then we discovered it was a separate location. So this is not a situation where we entered into that situation. We did not interview her about about that in any fashion. I would suggest that I have a law enforcement officer take her over there and have her walk through and see what she says about where it is. We'll just ask her to show us where you are, and she'll do that. The court says, as it stands right now, each of you is a witness, and if Ms. Macias is a witness, the defense has a right to examine you, which means that you are a witness. They didn't think about that one, huh? So whether that is a sufficient corrective measure, I don't know the answer to that right now, and I'm not going to deal with it. It's something that the DA will have to deal with. Mr. Gravely says, I don't understand what that means. The court says, well, you will have to decide. One of the attorneys could be excused from the prosecution. Mr. Birdsall says, well, they would have to get somebody else from their office. The court says they don't have to get anybody else. One of them can try it by him or herself. Mr. Birdsall says, but they are both witnesses. They are both subject to be called. The court says, you're going to call both of them? I might draw a line there. And he says, they would both have independent. And the court says, yeah, well, we are talking about angels on the head of a pin right now. Mr. Gravely says, why wouldn't we remedy this by having an officer taking her over there? The court says, I don't need to touch that. You won't be called for an error, as you know, unless you touch the ball, so I'm not going to touch it. We'll deal with issues as they arise. We don't have an issue about anything right now, so we are going to go on. We don't have an issue about anything right now. Mr. Gravely says, I apologize, Judge, but I don't understand. The court says, hold on one second. The court calls the jury on the jury phone, and he says, good morning and my apologies to the jury. I think I warned you folks on Monday that with 6 lawyers in the room, there could be some haggling down here. We are still at it. We are aware that you are up there, and we are going to get to you very soon. My apologies to everybody. Thanks. The phone call concludes. The court says, now, what did you want to say? Mr. Gravely says, we are at a point where no evidence has been put into this case, so if the court is indicating that you see a likely scenario where the defense would be able to call us, even if we were able to take this corrective measure, I am appealing to the court to take action today rather than wait until this witness will not be. The court says, what action do you want me to take? Mr. Gravely says, to give us guidance on what, why does he answer? To give us guidance on what the court wishes us to do in some fashion. Again, I'm willing to have an officer go there and independently talk to her about that. But the court says, I don't understand that could be something that might be done to ameliorate the issue, but they would still have a right to examine you. This is a risk. And this goes back to the case where it's a long Polish-sounding name from Milwaukee. E. Michael McCann has a witness. Oh, I don't remember. It was about 1968, and he was interviewing a witness on it was a double homicide of police officers, and it wasn't Mendoza, and have the witness cross him on the witness stand. No, he's like all over the place. No, it was 1974 maybe, but anyways, and the Supreme Court talked about this issue. Like, what? He really does think out loud. I mean, I do too, but I'm not a judge. Anyways, Mr. Gravely says, we don't have the capacity right now to have one prosecutor to do this. We have divided up the labor. So we are panicked by the court's sort of go ahead and see how it goes kind of scenario. We are in a practical level, not sure how we will be able to carry this on. So I just want to be sure that the court understands that this particular situation with the court is indicating one or under some scenario, both of us would be called as a witness in this case. We would need to have some court guidance before we start paddling down a river where the boat is going to sink at some point. And I apologize because I understand that the court feels like it doesn't have a sufficient amount of information for some of these pieces, but from the state's perspective, and I'm not going to, of course, speak for the defense, the division of labor here will not allow us to seamlessly do that. There is just too many masses of information here, and that we have divided this case up. This is not the court responds, this is not a problem of my creation. I love that response. And then Mr. Grayley says, well, I didn't mean to suggest it was, and I hope I did not. And the court says, you didn't. I'm just saying, I was trying to be unusually polite and say that it's your problem, not mine. I said, I think this should have been disclosed. I'm not at the point of saying you were required to disclose it, though. He says, sure. We shouldn't be having this problem had it been disclosed. You spent time on it during your opening statement. I was listening. It was very important. And this is a big detail, I think. So Mr. Gravely responds, so I am going to suggest to the court that in lieu of us traveling down a road where one of us will have to disappear from this trial, that a mistrial may be the appropriate remedy in that situation. The court says the jury has been sworn in a bench trial. The test is when a witness takes the stand. In a jury trial, it's when the jury is sworn. Mr. Gravely says, well, certainly we do not want dismissal of the charges, so I'm asking the court to consider making appropriate findings that do not create jeopardy. The court says, if you understand whatever findings I may make would be, the critical findings would not be findings, they would be conclusions of law, and the conclusions of law are easily dispensed with by the Court of Appeals. And if I were to declare a mistrial with whatever findings, and the findings are evident in the record, the real issue is the conclusions, and my conclusions may receive little or no respect from the Court of Appeals, and I'm not saying that there aren't jurists who might claim, assert, or rule that this was misconduct. I think it is pretty evident from what I have already said that I would not make that kind of conclusion. So he says that he realizes that there are people that would make that conclusion. He does not make the conclusion of misconduct. Mr. Gravely says, yes, the court says, but if I were to declare a mistrial right now, you would be running that risk that he could be found to have been committing some kind of misconduct on some part. So Mr. Gravely says, well, the alternative, if I understand the court's current scenario, is that there may be a situation sometime at any time where one of us would be removed from the case to testify, and the possibility is both of us could be removed. The court responds, or they could just be bluffing. Mr. Gravely says, or they could just be bluffing. And Ms. Muller says, not bluffing. I like her so much. Mr. Gravely continues, they have requested a mistrial. That was the beginning of their discussion about this. And if the court is willing to make a ruling that we are to proceed, or that the court is allowing the remedy of having an officer go and provide this information independently, then I'm asking the court to continue. If the court is not comfortable providing us some guidance, then I am concerned. I think I have expressed that. So I just want the court to have that in its thought process and see where we are. We categorically deny that we have engaged in any misconduct, and I think it has been patently obvious by the argument here that there is no authority for this particular statement having to be disclosed based on current law, either case law or statute, but I am concerned about this last issue, which is if the court rules at some point that one of the litigators of this case, when we have divided this up, that I am concerned about that in terms of our ability to finish the case. So I don't want the court to be aware, or I do want the court to be aware of what, and for us, of that, sorry. So I do want the court to be aware of that, and for us to have at least thought that through. So dividing up all the work between the lawyers, if one of the lawyer gets kicked off the case, and like the judge said, it's not his fault, or not his problem. It's your problem, not mine. He says, well, and all of this is dependent upon the defense having a good faith reason to call one of you as a witness, and that in my expectation would be if they are allowed easy access to you, which you would be obliged to do anyway, and to tell them what your recollections of the events were. Mr. Gravely says, and I have already done that. And the court responds, and if that is consistent with with what Ms. Macias says, then I think why would I let them call you as a witness? It's not for impeachment, so I can't see why they would do it in good faith, and then they would just be bluffing at this point. Wouldn't you think? Mr. Gravely says, now I have heard the court's thought process again, so I appreciate the benefit of that, so I'm better situated, and so I'm withdrawing any discussion I had of a mistrial. I'm ready to proceed now that I have heard the court think this through with me and my understanding. Ms. Mueller says, I guess I would just ask, well, there are multiple things I want to put on the record. First, when we first started this trial and I asked for a continuance based on several last-minute developments, the state talked about how, how many years he had been practicing. It's okay, Hazel. My dog's coming up the stairs and it's like freaking out the other dog. I don't know. Sorry. Where was I? So the state, let me grab a sip of water while we have a pause. There's Hazel. If anybody can see Hazel. There's Hazel. Hi, Hazel. You're on camera. Okay. Let me take a sip of water and we'll continue on. All right, so first, when we started this trial and I asked for a continuance based on several last-minute developments, the state talked about how, how many years he had been practicing and how there is never a perfect trial. A prosecutor who has been practicing as long as Mr. Gravely well knows not to interject himself as a witness. The court says, I have already said that, and I don't think it should have happened. I have told him, and the Supreme Court has aptly discussed it in the case that I refer to. So what is your suggestion we do at this point? Ms. Mueller says, thank you. I guess the defense's suggestion at this time is if the court's not going to entertain a mistrial at this moment, then the state are you asking for a mistrial now? We are asking for a mistrial based on what occurred here, with or without prejudice. The court asks, I guess, well, I don't think there is enough to go with prejudice. Ms. Mueller, correct. Oh, that was Mr. Aubert. Ms. Mueller says correct. Without prejudice at this point, meaning they could recharge Zachariah, but they'd have to drop the charges and then refile them. So there's obviously not enough on the record for that. All right, so the court at this point, it's the final point, because you are not going to say at this point without prejudice and then rumble off to the Court of Appeals and say, guess what? Mr. Aubert says, no, I don't think there is a record here that shows misconduct. Ms. Mueller says, thank you. Mistrial without prejudice. The other point I was going to make, though, is if that's not where the court is going to go at this point, I would ask that the state make Ms. Macias available to us so that we can get our investigators here to talk to her about what happened, so then we can have a little bit more insight moving forward. The court says, why don't we do this? Why don't you consult with another, first among your own group, and then with each other? We'll just take another 5 minutes so that everybody can be fully prepared to say what it is to be said, and my first instinct would be to try to save the trial. But if both sides are asking for a mistrial for different reasons, I would be crazy not to. I don't want to make this statement. Someone might take, okay, I don't want to make this statement. Someone might take, why is my computer flickering? I hate this stupid screen. It always flickers and then I can't read it. I'm not even moving. I don't want to make this statement. He says, I don't want to make this statement. Someone might take me up on it, but let's take 5 minutes. So they're taking 5 minutes. Mr. Gravely says, we are not requesting a mistrial at this point. The court says that is that is why I want you to consult with each other 5 minutes, 5 minutes, consult with one another first and then with each other, and then we'll see what happens off the record. Okay, so break was taken. The court reconvenes, and Judge Schroeder says, all right, we are back, and what's up? Mr. Aubert says, Your Honor, I only preface this by saying, regardless, this has nothing to do with whose fault it is or what precipitated this. I just want to point out that the very basics here in support of our motion for a mistrial that we are making. The court says, I didn't hear the very last 2 words you said. Mistrial what? He says, we are requesting a mistrial. That's what I wanted to start with. But without getting into whose fault it is, I just do want to point out that, as the court can see, we rely upon what's in particular what seems to be very clear statement that this witness is there, and there is no doubt about it with regard to that particular statement. After we tried numerous times, when the state comes into possession of something that is very different, and again, whether that was required to be disclosed or not, we conducted our entire opening argument and all the things that flow from that time frame in a particular way, which now has been theoretically blown out of the water. And with the amount of evidence and with all the dots that are connected here, we literally have to go back to the drawing board, strategically speaking. We've posited a theory based upon what we knew, based upon what was provided to us, that we anticipated certain facts coming out in reliance upon that, and the only people that knew that it was not going to come out that way was the state. And because of that fact, because of the fact that didn't happen, we had, and it's not just this particular fact, it's everything else that's connected to it in many different ways. As the court knows, this is a web of information, so we are going to be in a position where at the end of this trial, the prosecution very clearly will point out that we got it all wrong when we made our opening statement, and that our belief as to what occurred here is incorrect. And I just can't, for the life of me, figure out how we could have anticipated this any differently without being given the specific notice. So, pause real quick. We're almost done. Can you lay down, please? Lay down. Dog's being annoying now. So, he's saying there's no way that they could have known this change of information, and basically without the state telling them, obviously, because they're the only ones that knew this, and they created their whole strategy for their trial based upon Narita's timeline, where Narita was out, in front of Rosalio's apartment, supposedly. So it blows up their whole strategy, and they really have to re-examine everything about the case now. Continuing on, Mr. Aubert says, we did everything we could, and we thought that we had very solid timeline here that we have been depending upon virtually with regard to at least half the witnesses in this case that focus on that aspect of it. So, we don't want to be in position where we are asking for a mistrial, that there are, and we've talked about this. Obviously, the judge, as you can anticipate, there might be some strategic advantage to going forward given all of the kerfuffle that is going on. We acknowledge that. However, the bottom line is we made promises to the jury that we now don't believe we are going to be able to keep in reliance upon what the evidence was. So they base their whole theory, their evidence, the defense did get to continue on with so the opening statements happened with Gravely, he finished his, and then Nicole Muller had already prepared hers, and that's what she was going to say, and it had a lot to do on the dependence of Narita being in front of Rosalio's building. Hold on 1 second. Hazel, get off the blanket so you can get under the blanket. She stands on the blanket, but she wants to go under the blanket, and it's quite annoying. I bet she's cold because it's cold in the house today. I'm cold too. Anyways, let's get through this. We're almost done. All right, so So the bottom line is we made promises to the jury that we now don't believe we are going to be able to keep in reliance upon what the evidence was. So this is really kind of due process situation where we literally need to go back and account for this sea change in this particular issue and probably do more investigation, probably reconstruct how we are actually going to proceed with all of this. I bet you said key change, not sea change. I'm sure there's errors in here. All right, so again, trust me, Mr. Anderson, you know, we all don't want to do this if we can avoid it. Nobody wants, especially the defendant, doesn't want to go to a mistrial because, I mean, unless it's looking bad for them, then they would be happy for a mistrial. But usually, you know, a mistrial means you sit in jail longer waiting for your day in court. So most defendants, especially innocent ones, aren't going to want to wait any longer because they want to tell their side. They want their side told through their lawyers, at least. All right, so where did I leave off? But we can come to the conclusion that it is just necessary because it's a huge flaw in how we presented it. And I don't see that we would reasonably have been expected to not rely upon what again appears to be a very clear statement. This whole argument that just because someone says they're there doesn't mean that they are actually there, you know, and so on. And it didn't occur to the prosecution until they actually went on a road trip with the witness. So I think all of this just necessitates a mistrial. The court says, well, you are not identifying the nature of the mistrial that you are seeking. Aubert says, well, it's because I'm talking about the necessity for it, and I don't know, I believe, and I could be very wrong about this, but I think the court should make the findings as to, and maybe I'm wrong, the court says, I could not make findings sufficient to support a mistrial with prejudice unless we have the trial. Mr. Aubert says, got you, and we understand that. The court says, and there is not enough information in here, so if that's what you are seeking, then the motion is going nowhere. Mr. Aubert says, I understand, and I know there is not really a record here at all, so I'm talking about the need for a mistrial. If this means without prejudice, fine. The court says, the state. Mr. Gravely says, so what was represented to myself by counsels was that they are not requesting a mistrial based on asking the court for prejudice. They are not specifically alleging misconduct, and I believe that what counsel just said in an argument that does not specifically allege misconduct, and that they are requesting that the court keep their speedy trial in limbo, especially as they did as we approached this issue Monday, and that we take the second week in September date that we identified previously and litigate this case at this time. If those representations continue to be the case from the defense, then we do not join in the motion for mistrial, but we do not object. But again, it would be if I have correctly stated the representations that I think I heard. The court says, now when you are talking the second week in September, what is the exact date? The clerk says September 12th. The court repeats that. The clerk says, which would go into the week of September 19th. Mr. Gravely says, right. So all the attorneys were able to, the court says, will need to be done by about the 27th at the latest, which is 2 days beyond 2 weeks. Mr. Gravely says, into the third week, I think all parties are confident that, Mr. Aubert says, part of going through this process in the past few days has actually narrowed some issues quite a bit, so I think that this is reasonable. The court says, all right. Mr. Gravely says, did I correctly represent counsel's position that they are simply asking that their speedy trial be suspended until, I don't know what the word was, but suspended until the second? Mr. Aubert says, that the time period be excluded in the interest of justice because we are asking for the pretrial. Mr. Gravely says, and that they are not alleging misconduct specifically, and that they are not requesting that this be dismissed with prejudice. Or, the court says, he has avoided the use of painfully, I might add, avoided. Mr. Gravely says, I just want to make sure we understand it is a strategic set of calculations and a representation which the state, based on those representations, does not join in but does not object. my God, this guy talks in circles, man. Mr. Robert says, I have made the record. The court says, okay, just to supplement the record, the judges, we are encouraged to make all these findings when I go to the judge's school, but some of them are so evident from the record, and one of them is that the defense asked to adjourn this case when we started and had other reasons other than this, so they were certainly comfortable with the proposition of adjourning the case until September the 12th. So remember, this is March 16th, 2022 is the day that this conversation is taking place. So they're delaying the trial until September. And now this latest development, which I haven't indicated, I don't think should have happened. But I also have not found and do not find that it was any kind of dereliction of, well, this is the wrong word. Well, it isn't dereliction of duty, and it isn't misconduct that has been identified, and I certainly would not embrace the suggestion that there is any evidence in the record of that at all, and I couldn't make that determination until I heard a lot more than I have heard. From what I've heard, Gravely does this kind of shady crap to a lot of his defendants, so like trying to change testimony, witness statements, and evidence and whatnot. He has a reputation for misconduct. I don't know if he's ever actually been reported for it or sanctioned for it, but he's definitely has a reputation of not necessarily playing fair for everybody. All right, so he says it was not misconduct. He certainly doesn't want to embrace the suggestion that there is any evidence in the record of that at all, and I couldn't make the determination till I heard a lot more. Okay, so there would be absolutely no basis in the evidence or in what's been stated here to justify a mistrial with prejudice on grounds of prosecutorial misconduct of any kind. So I'm going to grant the motion for mistrial with the unopposed motion of the defense and adjourn the case to the 12th of September. We'll have a pre-trial just to make sure everything is in the right place coming into the trial. And anyway, September the 12th, the trial, give them a pre-trial. Okay. The clerk says, how about the 29th of August at 1:30, Mr. Gravely? And what time did you say? 1:30. August 29th works for everybody from our perspective. Mr. Gravely says, I have a jury trial in branch 2. Clerk says it is a pick and go, Mr. Gravely. Or, Mr. Gravely, not sure. Can you look this up? We'll check. Which is actually my next question. The clerk says, do we want to do a pick and go on this date or pick and go on Tuesday? Mr. Gravely says, I think the jury selection is lengthy enough that I would suggest we do not pick and go, but that we wait until the second day. Ms. Mueller says the defense would also suggest that. The clerk says, I'm looking at it right now. Jury selection could we do it slightly later in the afternoon, August 29th for the pretrial? Can we do it by Zoom, or do you want them here in person? Is 3 okay? Mr. Gravely says 3. We'll do it in person. If something changes, let me know. Yeah, I will. Got it. Okay. Jury enters the courtroom, and then the court says, basically, this is a mistrial, and we don't need you. Thanks anyways. Have a great day. Everyone's excused. So that is the mistrial of Zachariah Anderson. In our next episode, we're going to talk more about Prosecutor Gravely and how that all goes about. Because after this whole thing that happened, and the mistrial was caused mostly by Mr. Gravely failing to disclose information and discovery to the defense team. So because of that, we get a whole new trial. And that takes place, it actually does not take place September of 2022. It took place in, I believe it was March of 2023. So again, this is now 3 years after Rosalio goes missing. Still haven't found a body. Still don't have any evidence specifically to tie Zach to Rosalio's body, or any kind of weapon or anything of that nature. So it's just very curious, don't you think? So I'm going to leave it at that, and we'll talk next time about Gravely and trying to get him kicked off of this case. So we're going to talk about that because the defense files a motion to remove Gravely from the case, and we're going to read that in the next episode. So please, if you've got questions about this case, feel free to leave them in the comments below. Don't forget to let me know what you think about this case and what you think about Gravely here causing this mistrial. Do you think that's his fault? What do you think? I mean, he definitely should have. I mean, no doubt should have told the defense about this change of events. But I almost feel like it was coordinated by the prosecution. Why else would Narita not want to talk to the defense? If the prosecution is like, come on, be on our side and don't listen to the defense, don't talk to them, don't even answer them. That's what I think is happening here. But it's my speculation. So anyways, let me know what you think. Don't forget to like this video, subscribe, and I will see you in the next one. Take care. Bye.